Welcome to Literal BS, the podcast dedicated to empowering you with knowledge about your constitutional rights. I'm your host, Rob, and today, we're tackling a topic that directly impacts our daily lives in the digital age: government spying and its collision with the Fourth Amendment. For generations, the Fourth Amendment has been our shield, promising us security in our persons, houses, papers, and effects from unreasonable searches and seizures. It's the reason law enforcement generally needs a warrant, signed by a judge, based on probable cause, before they can search your home or seize your property. This fundamental protection was designed to prevent the kind of unchecked government intrusion that characterized colonial rule. But what happens when our papers and effects aren't physical documents in a desk, but rather digital footprints scattered across the internet, emails, text messages, browsing history, even our location data transmitted by our smartphones? This is where the historical intent of the Fourth Amendment faces its greatest modern challenge. Let's quickly revisit the basics of the Fourth Amendment. Its core is simple. Government agents can't just go rummaging through your stuff on a whim. They need a good reason, supported by evidence, and usually, they need a judge's permission in the form of a warrant. The warrant requirement is key. It acts as a neutral arbiter, a judge, standing between you and the government, ensuring that any intrusion into your privacy is justified. Historically, this applied to physical spaces. Your home was your castle. Your letters were private. But with the advent of the telephone, and then the internet, the nature of papers and effects transformed. For a while, legal interpretations struggled to keep up. The third-party doctrine, for instance, argued that if you voluntarily shared information with a third party, like a phone company or an internet service provider, you gave up your expectation of privacy in that information. This was a significant loophole, allowing for broad data collection without warrants. Then came the digital revolution, and with it an unprecedented capacity for surveillance. Think about it. Your smartphone, a device you carry everywhere, constantly generates location data, records your communications, and tracks your online activities. Cloud services store your most personal documents and photos. Social media platforms capture your thoughts, relationships, and daily routines. Following events like 9/11, national security concerns led to the expansion of government surveillance programs. We've heard about the NSA collecting metadata on phone calls, the FBI accessing vast databases of personal information, and the increasing use of facial recognition technology. The justification often hinges on the idea of incidental collection or the need to counter terrorism. But here's where the Fourth Amendment comes into sharp focus. When the government collects massive amounts of data on ordinary citizens, even if it's metadata or collected from third parties, does it truly align with the spirit of protection against unreasonable searches? Many argue it doesn't. The Supreme Court has slowly started to catch up. In cases like Carpenter versus United States, they recognized that even seemingly benign data like cell site location information can paint a highly detailed picture of a person's life and therefore warrants constitutional protection. This was a crucial step in reining in the third-party doctrine in the digital realm. The problem, however, remains. Laws like Section 702 of FISA, designed for foreign intelligence surveillance, are often criticized for allowing backdoor searches of American citizens' communications without a warrant, simply because those communications were collected incidentally. This means intelligence agencies might collect communications between a foreign target and an American citizen, and then domestic law enforcement could search those communications without ever getting a warrant from a U.S. court. This feels very much like the general warrants our founders fought against. Beyond the realm of large-scale surveillance, the Constitution also provides crucial protections against individual acts of corrupt or overzealous law enforcement. The Fourth Amendment's warrant requirement and probable cause standard are direct checks on police power. An officer can't just kick down your door or search your car without a legitimate reason. If they do, any evidence they find might be excluded from court under that exclusionary rule. Furthermore, the Fifth Amendment's Due Process Clause ensures fairness in legal proceedings. This means law enforcement must follow proper procedures from arrest to interrogation. Your right to remain silent, the famous Miranda warning, comes directly from the Fifth Amendment, ensuring you're not compelled to incriminate yourself. And if those rights are violated, there are legal avenues to challenge it. The Sixth Amendment guarantees your right to a lawyer, to a speedy and public trial, and to confront your accusers. These are all vital safeguards against wrongful conviction or abuses during the legal process. And let's not forget the 14th Amendment. Its due process and equal protection clauses mean that these rights apply not just to the federal government but also to state and local law enforcement. It also means that police cannot discriminate against you based on race, religion, or any other protected characteristic. So, what does all this mean for you? First, know your rights. Understand what the Fourth Amendment protects and that warrantless spying on your digital activities is increasingly being challenged as unconstitutional. Second, be aware of privacy settings on your devices and online accounts. While these aren't constitutional protections, they can limit the data you voluntarily share. Third, support organizations that advocate for digital privacy and civil liberties. The fight to adapt our constitutional protections to the digital age is ongoing, and it requires vigilance and advocacy. The Supreme Court's decisions in recent years suggest a growing recognition of digital privacy, but the battle is far from over. The U.S. Constitution, with its Bill of Rights, remains our most powerful defense against government overreach. It's not a dusty old document, it's a living shield, one that we must understand, uphold, and actively defend in the face of evolving challenges. As we close out this episode of Literal BS, I want to leave you with this powerful truth: the Constitution isn't just a document written centuries ago. It is a living, breathing promise of liberty, and your Fourth Amendment rights are the very breath that keeps that promise alive in the digital world. It is your right to privacy. It is your right to be free from unwarranted intrusion. In an age where our digital lives are so intricately woven into our very identities, understanding and asserting these rights is no longer just a legal nicety, it is a fundamental act of self-preservation. Stay informed, stay vigilant, and remember, the unseen chains that protect your liberty are only as strong as our collective will to defend them. Your rights are not gifts, they are the bedrock of our freedom. The purpose of today's episode was to shed light on our constitutional rights because legal literacy is essential in our democracy. Many Americans remain unaware of the fundamental protections afforded to them, and this knowledge gap can have serious consequences. By understanding our rights, we empower ourselves to navigate complex legal situations and hold our institutions accountable. This is Rob signing off. See you next time.